Good evening to you all. So in the series of question solving, as the series is named as Polity through question. So in this video we are going to discuss next chapter, which is related to governor. So through this question solving we will also try to cover all the aspect of governor. What are the various constitutional provision regarding the governor. So this is our prime motive behind making these videos, so that you can understand the concept and the type of question which are asked from that topic. So coming to the first question, the original plan in the draft constitution for having elected governor was dropped because it would have meant another election. Yes, for direct election there would be another election. The election would have been fought on major political issue that we will see. The elected governor might have considered himself superior. There would have been a clash between both elected person, the chief minister and the governor. The governor had to function under the parliamentary system. So before going into this statement, I would like to tell you about a brief background about the appointment of the governor in the draft constitution. So before the constitution was came into force, the draft was prepared. That's why we are calling it as draft constitution. So there were debates about the appointment of the governor. So this draft constitution provided for two options for the appointment of a governor. First was that direct election, and second was that appointment by president from a panel of 4 persons elected by legislative assembly. So the draft constitution provided for the two options. First is the direct election for the appointment of the governor, and second was that appointment by the president from a panel of 4 persons elected by the legislative assembly. So there was a role of legislative assembly of that state in the appointment of a governor. But this was in the draft constitution. But when the real constitution came into force, these both options were discarded, and the third option was created, that was appointment by not appointment, it was nomination. We should call it nomination by president. So the president nominate the governor. So this was the provision which was provided in the constitution, which came into force. We all know that 26 November 1949 it was adopted, and it came into force on 26 January 1950. So this was the basic background behind this debate about the appointment of the governor. So various reasons were given that why should not be there direct election, and why should there be instead of upon direct election there should be nomination by the president. So there was various reasons given by the member of Constituent Assembly at that time. So some of the reason, so these are the reasons which are provided in this question, that why didn't we why didn't we adopt the elected governor, that is the directly elected governor. So first statement is that if the government would have been directly elected, it would have meant another election. So that is a simple statement that is true. The elected governor might have considered himself superior. So we know that there would be two persons. First is chief minister and second is governor. So there would always be a conflict between the governor and the chief minister, because both are popularly elected, that they are directly elected by the people. Governor had to function under the parliamentary system. So uh, the direct election of governor was becoming a hurdle, or we can say that uh, this was not suited with the this was not compatible in the parliamentary system, because we know that in the parliamentary system there are two executive. First is nominal, second is real. So as we know that the real power lies in the hand of chief minister and the council of minister, and the nominal power lies in the hand of governor. So this was creating a conflict. In fact, we must say that it was not compatible with the parliamentary form of government, which is one of the basic feature of parliamentary form of government. So in this question, only the reason that why didn't we select the appointment of governor as directly elected by the people, why we selected the nomination of governor by the president. So these are the various reasons given, and these statements are put into place in this question. So you can in this way solve this question. The governor had to function under a parliamentary, so I told you that it was not compatible with the parliamentary system, so this statement is true. Elected, I told you that there might be a conflict, this is also true. Election would have been fought on major political issue, so this statement has can be eliminated on the basis of that, as we know that the governor didn't have any major power, as he is the nominal executive. So we know that the real power lies in the hand of chief minister. So this election, instead of fought on major political issue, it must have been fought on personal issues, because there is already a chief minister who is fighting on the major issues, because he has, or she has a real power. So these are the statement, and in this way we can take out the correct answer, that is first is true, second is true, third is true. So option is 1, 3, 4. So coming to the answer, which we have hided, try to hide so that you can also guess out the answers. So answer is C. So this is right answer. So before going to next question, I would also like to tell you some basic fact about the governor. So this office of governor has been taken from Government of India Act, which was passed in 1935, and it its appointment is on the basis of that, and this appointment, how the manner of appointment has been taken from the Canadian Constitution, where the Governor General at the center appointed the governor in the provinces. Third, you must always remember the basic broad idea about the governor. That governor, as we know that there are two executive, real and nominal. Nominal is the governor, and the real is CM and his council of minister. And we must also know that governor is a part of executive. So in this way, if we talk about the state executive, then this state executive comprises of governor, CM and his council of minister, and third is advocate general. So this similar setup has also been provided at the center level also, which we have discussed. In the center we know that it is attorney general, the prime minister, council of minister, and the president. At the state level, this is all about the state executive. And if we talk of the state legislature, then we know that governor is also part of legislature, because without his assent a bill cannot become law. So we know that the major primary task of legislature is making laws, and without the governor assent or signature, a bill cannot become act. So cannot become a law. So governor is also part of state legislature, and legislative assembly plus legislative council. There are some states where the legislative council is also present. At present, there are 6 states. Uh, so this is about the legislature. This is about the executive. So in this way, you can get a broad idea that what is the state executive, what all comprises of a state executive, and what all comprises of state legislature. And if we talk about the appointment, then I have told you earlier that the governor is appointed by the president. And the basic thing to remember about this appointment is that governor, office of governor, you must remember that office of governor is not a employment under central government. So if the question asks that it is the employment under central government, so employment under central government. So in a Supreme Court ruling in the 1979, which was a famous case in 1979, Hargobind Pant, Hargobind Pant versus Raghukul Tilak and others. The Supreme Court ruling said that it is not a employment under central government because it is a independent office. It is a independent office under constitution. So it is not subordinate. It is not subordinate to central government. So this the small thing you must remember, that it is a independent office under Constitution of India. It is not a employment under central government, neither it is subordinate to the central government, because we know that governor is appointed by the president. We know that president, how the president works. It works on the aid and advice of the central government, that is the minister, prime minister, and council of minister. So sometimes the various misuses of the governor post are done by the president or the central government. So coming to the next question. So this is all about the basic introduction, on which basis you can solve question, the basic question. Now coming to the next question, which is the governor of a state may act independently from consultation of legislative assembly. So like in the case of the president, we discussed that the president act on the aid and advice of the prime minister and his council of ministers under article 74. Here also under article 163, the governor act on the aid and advice of CM and council of ministers. So these are the basic things which you can remember, or you can understand the concept of. If you can get the concept of parliamentary system, then these things can easily be understood, that who give the advice to whom. So this is the basic setup of our country. This is the basic parliamentary setup of India. I told you that it act on the aid and advice of the CM and the council of minister, but there are some discretion provided to governor, because if we read from the statement which says, like under article 163, it says that there shall be a council of minister with chief minister as head to aid and advise the governor in exercise of his function. So this is the basic statement, but in addition to it says that there shall be a council of minister with CM as the head to aid and advise the governor in exercise of his function, except so far he is required to function in his discretion. So that this word discretion has been clearly written in under Article 163, that the governor has some discretion, though he is constitutionally bound to work on the aid and advice of the COM plus chief minister, but there are some circumstances, there are some constitutional discretion, there are some situational discretion where the governor work independently. So in this question, in a way it is asking about the discretionary power of governor. So coming back to the question, the governor of the state may act independently from consultation of legislative assembly. So I told you that the discretion word has been clearly written in under Article 163. Unlike the president, there is no such word discretion used in the president. So before solving this question, I would like to tell you that I told you that discretion has been there. There are two types of discretion: constitutional and situational. Constitutional discretion are those discretion which are written in the constitution. So they are explicitly written in the constitution, where the governor act on his discretion, and there are some situational discretion which are the interpretation of the we can say that is a provision of the constitution. So they are not clearly written, but in a way they are discretion, they are situational discretion, they are the interpretation of the provision when the governor act according to his discretion. If we take example of the constitutional discretion, we can take example of that. First we can take example of reservation of bill for consideration of president. So we will discuss about these various assent power of the governor, but there is a provision that governor can reserve a bill passed by the legislative assembly for the consideration of president. Second thing is that if you have read article 356, that is about the president rule. So there is a provision that the governor can recommend for the imposition of president rule. So governor can recommend for the imposition of president rule in his state. So that is also a constitutional discretion. They are written in the constitution, so they are called constitutional discretion. Some other example are while exercising any function as a administrator of UT. So as a administrator of UT, if he takes certain action, then he or she can act in his discretion. So that is also there. There is one another discretion, it is determining the amount payable by the government of these four states to the autonomous tribal district. We know we will read about these. There are in these areas, there are 6 scheduled areas, there is a concept of autonomous tribal district. So what will be the amount given by the government of these state to the autonomous tribal district? So that is also decided by the governor. So these are some of the example where there is a constitutional discretion, the discretion which are clearly written in the constitution. Coming to the situational discretion. Situational discretion. Situational means they are not clearly written, but they are interpretation of the provision of the constitution. Like first we can say that appointment of chief minister, appointment of chief minister in a case of hung parliament. We know that hung parliament when no party has clear cut majority in the state legislature. So in that case what the governor will do, so there are some criteria that he will go to the first he goes to the largest party, the largest party which has the largest party means the party which has the largest number of MLAs. Second, any pre-poll alliance. In the first case also it can go for a party which has a pre-poll alliance and is having the majority. So it can go otherwise also if he thinks that the largest party does not have any coalition and there is a pre-poll alliance which has a majority. So president and the governor can call the pre-poll alliance also. Third is the post-poll alliance. Post-poll alliance. So we will read about these processes, what happened in the case of hung parliament or hung assembly. I have told you earlier also. So these are the situation and these are the option behind before the governor while there is situation of hung parliament. So one case is also there where the governor appoint a person as chief minister of some party and seeks and he in his discretion he think that he can get majority, so the governor give him some time to prove his majority within a certain period, specified period, like 1 month. So this is also the on the discretion of governor. So these are the situational discretion. This is the first situation when there is a situation of hung parliament. Second is dismissal of council of minister when it cannot prove confidence. Suppose a no confidence motion is passed in the legislative assembly, then the governor dissolve the council of minister. Third is dissolution of state legislative assembly if it has lost majority. So these are certain situational discretion which are provided to the governor. And in addition to the situational and constitutional discretion, there are other discretion also where though the governor consult the council of minister but finally act on his discretion. Like I will give you some example. Like in case of Maharashtra, establishment of a separate development board for Vidarbha and Marathwada. So like in case of Gujarat, Nagaland, Assam, in Assam, like with respect to administration of tribal area in Assam, administration of tribal area. So there are some discretion provided to governor which are wider than the president, because president has not been given such discretion as of the governor. So sometimes it is called the governor has a wider discretionary power than the president. So coming back to the question, so this question is talking about the discretionary power only. So first is that the government has to prove its majority in the session of legislative assembly. Yeah. Yes, the government has to prove its majority in the state. Suppose the governor think that the party does not hold majority, the ruling party does not hold the majority, so it can ask the government to bring confidence motion. So it can ask for government to prove majority, like in case of confidence motion. To terminate chief minister, so I told you, in case a no confidence motion is passed, governor can dismiss council of minister. Governor dismisses council of minister. To reserve any bill for consideration for the president of India, so that I told you that it is also a part of discretion. To send back bill, that is also discretion. To seek consultation with High Court, though the governor seek consultation with the High Court, like in the case of appointment of district judge or in the appointment of judicial officer, he also consult the High Court, but that is not the discretion, that is on the aid and advice of the CM and Council of Minister. So in this way, you must always remember that there are two type of discretion: constitutional and situational. So and you must differentiate between both situational and constitutional. Constitutional discretion are those which are clearly explicitly written in the constitution, and situational are that they are hidden discretion, they are not clearly written in the constitution. So this question is not asking the classification, but question is asking about the discretion. So I told you that these are the discretion, this is not a discretion. So the answer is 1 2 3 4 A. So I have discussed at length about the various appointment of president, appointment of governor, sorry, the discretionary power of the governor I have discussed. So in this way we are solving question and also going in the conceptual clarity. And here you must remember that president has only situational discretion. If the question says that president has constitutional discretion, so always it is wrong. President, it is clearly written that president has no constitutional discretion, while the governor has both constitutional and situational discretion, and president has only situational discretion. No constitutional discretion has been provided to the president. So that you must always remember. Coming to question number 3, under which of the following article of Indian Constitution governor may reserve a will for the consideration of the president? So though the article is 200, but I will discuss about the power with regard to the bill, signing of the bill. So what are the various power of the governor? Though I am taking time in telling you about the various provision of the governor, in the coming question we will be able to easily solve the question. So this is about the reservation, this is about the bill, assent power of governor. So coming to the fundamentals, though it is article 200 Let's talk about the veto power of governor with regard to various bill. So first we will take ordinary bill. So in case of ordinary bill, what happens? What are the various options provided for the governor? First is that he can give assent given. Second is that he may withhold assent, that he does not give assent. Third is that he may, which I am representing with question mark, that he may return bill for reconsideration of legislative assembly. So this is the third option. And fourth option is that he may reserve bill for consideration of president. So these are the four alternatives provided for the governor with respect to the ordinary bill. He can give assent, he may withhold assent, he can return bill for the consideration of the legislative assembly, that we call it suspensive veto. It is called absolute veto, and it is not veto because it has given the assent. Here the assent has been given. And this is the fourth option, where a bill is reserved for the consideration of the president. So we will discuss this about in detail. Like, this is about the ordinary bill. So here going to this reservation of bill for the consideration of president, discussing it further. A bill has to be mandatorily reserved for the consideration of president in some situation when state legislature endanger position of high court. So when the state legislature make any law which is endangering the position of high court, then it is mandatory on the part of governor to reserve that bill for the consideration of president. Second is that when there is a bill with regard to concurrent subject in concurrent list. So we know that in the concurrent list the law can be made by both parliament and the state legislature. But in case of conflict, the parliament law prevail over the state law. Like in case of NEET, this NEET bill by Tamil Nadu, which is recently in controversy, that this bill was not passed by the governor. Governor was doing nothing, was sitting on that bill. So this bill, as we know that the medical education is under the concurrent list, so that bill must have to be reserved for the consideration of president, because there are already law of the parliament on this medical education, on this NEET, and the state legislature is also entering in that field. So there may be situation of conflict between both law. So in that case, the governor has to reserve that bill for the consideration of president. So I gave you the example of NEET, where the Tamil Nadu government is is asking for the exemption of NEET exam for the student of Tamil Nadu. They can, so that they can provide their provincial exam. So these are some situations where the bill has to be mandatorily reserved for the consideration of president. Suppose what happens when it is reserved for the consideration of president. What are the options to the president? So what president can do? So president, when the bill is reserved and it comes to the president, now it's up to the president what the president will do. He can give assent, he can withhold assent, and he can return bill for the reconsideration of the legislative assembly. But here the clause is that the house have to return that bill within 6 months after reconsideration, so that the bill which is returned by the president has to be returned by the state legislature within 6 months. Or but here the provision is that if it is suppose it is returned of 6 months, then also the president is not bound to assent that bill. So if again the bill is returned to the president, then the president is not under obligation to sign that bill. And in the case of governor, I forgot to tell you that in case the governor return the bill for the consideration of legislative assembly, if it is again passed by the legislative assembly, then the governor has to mandatorily sign it. Like in case of president has to sign. So here the case is also same. The governor has to sign it. He cannot withhold after it returned to the governor after reconsideration. So this is all about the veto power of the governor and the condition I told you when it is reserved for the constitutional president, then what president can do. And this is all about the with regard to the ordinary bill. And if we talk about the money bill, that was all about the ordinary bill. And if we talk about the money bill, then what can happen? Suppose a bill come to the governor, then what happens? He may give assent, he may withhold assent, and we know that in the case of parliament we know that a money bill cannot be written. It means that suspensive veto is not there for the money bill. But here same option is there, that the governor can reserve bill for consideration of president. In the case of ordinary bill, this option was there. It can use the governor can use suspensive veto. But in case of money bill, the governor cannot use suspensive veto. Other three options he or she can use. Suppose the bill further situation arises. Suppose a bill is reserved for the consideration of president, then what the president can do? President can give assent, president can withhold assent. President, here the president in the same and the governor cannot return. The president can also not return. That is, the president cannot use suspensive veto. So here the suspensive veto is not provided for the president also. But so these are the options. He can withhold assent. These are three options to the president. And one thing you must remember, that when the bill is reserved for the consideration of the president, then it is the task of president only, that what has to be done with that bill. The governor does not have any role after it goes to the president. So this is all about the veto power of president with regard to the ordinary bill and the money bill. So I hope that have you must have got this conceptual clarity about the various veto power of the governor with regard to money bill and ordinary bill. So I told you in detail, but this question was just asking about the article, and this article is Article 200. Coming to next question, under which article for the approval of president? This is Article 200. Coming to next question, who is the constitutional head of the state? So I told you that constitutional head of the state, there are two words where I use this: head of government, head of state. Head of state is always the governor in case of state government. Like in case of uh, state, word is used in the sense of whole India also, and in the provinces also we call it state. So head of state, constitutional head of state is state government is governor, and head of government is always the person who has a real power, that is chief minister. So these are the trivial words which are sometimes used to just distract the student. Constitutional head of the state, governor. So as we have discussed about the details of the governor, and now we can easily solve this question: who appoint the governor of Jammu and Kashmir? So at present we know that Jammu Kashmir is a UT, and what happened in the UT? Though the Jammu Kashmir Reorganization Act provide for a state legislature, but at present there is no elected state legislature. Elections are yet to be held in the Jammu and Kashmir. So in these legislature, suppose the election of state legislature take place, there will be a CM. So CM is they are appointed by the president. But in case we know that who appoint the governor, so there is nothing different. Who appoint the governor? That is the president of India. The governor are appointed by the president of India. And always remember, in the UTs, the CM is elected by the CM is appointed by the president. Coming to next question. Question number 7. So I think this video has been too long, so I will try to make another video as possible. So in that video we will try to complete this chapter of governor. So if you like our video, please subscribe. Please do comment in the comment section if you like our videos, so that we can improve and we can get your constructive feedback. Thank you and have a nice day.